Russia's parliament has just approved 14 restrictions on citizens who were convicted at home and then left. Frozen accounts, dead signatures, a passport that expires with no replacement, and one final measure that closes the exit door completely on potentially 10,000 citizens overseas. We'll cover what this scheme means and how Russia may drag other countries into its plans. On July 24th, Russia's Federation Council approved 2 bills at the closing sitting of the spring session. The State Duma, the lower house, had passed both unanimously 2 days earlier. Neither text is law yet, and the president has not signed them. But when he does, they take effect on the day of official publication, with no transition period or grace window for anyone affected. The first bill is a freestanding statute that contains the mechanism, the 14 measures themselves. The second law threads consequential amendments through roughly a dozen existing laws. Among them, the Consular Charter, the fundamentals of notariate legislation, and the statutes governing registration of real estate, vehicles, licensing, state services, and consumer credit. That second bill is not getting the media attention the first one has received, yet it's the reason the measures will function across so many different agencies at once. 3 conditions must coincide before any of this applies to a person. 1. A criminal sentence or an administrative penalty ruling must have entered into legal force. 2. A competent authority must confirm the person is evading execution of that punishment. 3. And finally, their departure from Russia must be confirmed. Criminal convictions qualify under any article of the Criminal Code. Administrative penalties qualify only under a closed list, and that list is where the political dimension is relevant. Foreign agent violations, public discrediting of the armed forces, calls for sanctions against Russia, calls to violate territorial integrity, and participation in organizations Russia has designated undesirable. This plan reaches citizens already convicted, not people merely facing charges. So, how many people are we talking about? When the package was introduced in December, the chairman of the Duma's Security and Anti-Corruption Committee said 10,593 Russian citizens were on international wanted lists that month, most of them outside the country, and described the group as fraudsters, corruption defendants, terrorists, and murderers. Supporting materials cite prosecutor figures showing foreign states refused to extradite 109 people over 11 months of 2025 after refusing 102 extradition requests the year before. Financial restrictions dominate the 14 points of the plan. Banks must refuse credit and loan agreements. Banks must also block access to their mobile applications and websites for money transfers. So the person loses the interface before they lose anything else. Funds and other property are frozen, with narrow exceptions. Frozen money goes into a special ruble account at an authorized bank, on terms the central bank will set. Close relatives without independent income may receive a monthly humanitarian allowance drawn from those funds, decided by an interagency commission whose composition the president approves by decree at a level the government sets in agreement with the central bank. In practice, a family's income becomes a discretionary payment from a committee. Creditors are not forgotten either. Organizations and individuals who suffer property damage because a listed person cannot perform an obligation may recover that damage, plus their legal costs through the courts from the frozen property. Beyond the money, a second group of measures targets everything a Russian national owns or wants to own. Registrars return applications for cadastral registration and for registration of rights to real estate without considering them. The law bars vehicle registration and restricts driving rights. It blocks registration as an individual entrepreneur or as a professional income taxpayer, which closes the 2 simplest routes a Russian citizen has to earning legally declared income. A third group goes after legal capacity itself. Agencies withhold state and municipal services in electronic form. Licenses and accreditations are refused or suspended. Notaries decline to perform acts on the person's behalf. Powers of attorney no longer function. Electronic signatures are annulled with no route to a replacement. Think about what that combination produces. Someone with an annulled electronic signature cannot sell property, cannot authorize a relative to act for them, cannot file a document with any agency, and cannot appoint anyone to fix it. On paper, they exist. Functionally, those rights have been switched off. Everything so far applies inside of Russia. Consular measures, however, reach the national abroad. Consulates will decline applications for a new foreign travel passport. They will decline registration of a marriage or a change of name and reject legalization of foreign documents and retrieval of personal records. And, most significantly, they will outright ignore applications to renounce Russian citizenship. So, the state will not take the passport away, nor let the person give it back. Withholding travel documents is among the standard levers governments use to constrain movement, and it works on a delay in this case. It expires on its own schedule, and no replacement arrives. A person with 3 years left on their passport has 3 years to solve a problem they may not know about yet. Under the adopted text, the Ministry of Justice decides whether to apply and lift the measures. Restrictions begin the day after a person's details appear there. 5 bodies may submit candidates: the Prosecutor General's Office, the Interior Ministry, the Federal Security Service, the Federal Bailiff's Service, and the Federal Tax Service. Confirming that a person is abroad and evading falls to the Interior Ministry. This arrangement is new. When the Duma passed the package at first reading on December 18th, the decision belonged to the Prosecutor General's Office. Of 11 amendments adopted unanimously over the 7 months that have followed, 2 were described as principal. One moved the decision and the list to the Ministry of Justice. The other named the 5 bodies entitled to submit candidates. An administrative ministry, rather than a prosecuting authority, now controls who goes on. The entry date moved too. Reviewing the December text, the Federation Council's Budget Committee recorded that the provisions would take effect in March 2026, and that implementation would require no additional federal budget spending. The final version dropped the delay entirely. So this may beg the question. If one finds themselves on the list, how do they get off it? The measures lift on several grounds: quashing of the sentence, deferral of or release from serving it, confirmed execution of the punishment, return to Russia, or death. Someone who should just be delisted but is not may file a reasoned application with the Ministry of Justice, which has 20 working days to decide, and a refusal can be appealed in court. Nothing in the package sets an outer time limit. Absent one of those grounds, the restrictions continue indefinitely. First Department, a legal aid group working with defendants in politically motivated cases, published an analysis of the bill in December and updated it this month. Its lawyers argue the design amounts to de facto deprivation of citizenship, because the state retains its jurisdiction and its claims over the person while withdrawing most of what citizenship normally provides. Their term for the result is the cancelled citizen. Someone abroad for political reasons, designated as evading, holding a passport that has shed many of its rights and none of its obligations. Worth noting that their analysis describes the bill rather than the adopted text, and it identifies the Prosecutor General as decision-maker, which the final version changed. Now, the reason the mechanism was built this way instead of through outright revocation is the interesting part. States that strip nationality risk creating statelessness, which international law treats as a serious problem. And that's why most countries expanding citizenship-stripping powers confine them to dual nationals. Emptying citizenship of its content while formally preserving it sidesteps the question, which means the protection most people assume they have, that a government cannot leave them with nothing, does not apply here. So, what happens next? Under Article 107 of the Russian Constitution, an adopted federal law goes to the president within 5 days, and he signs and promulgates it within 14 days. Counting from July 24th, the outer limit falls in the second week of August, though laws like this routinely move faster. Publication on the official legal information portal is the operative event, not the signature. That portal, rather than any government press release, is where the restrictions become available to the Ministry of Justice. A related measure is already on the statute book. The President signed a law on June 10th expanding the list of administrative offences for which Russians abroad can be held liable and permitting seizure of their property as an interim measure. Takes effect on September 1st, and it originated separately from a regional bill sent to the Duma in 2024 on liability for offences committed abroad against Russian interests. Nothing about this mechanism is technically specific to Russia. It doesn't require cooperation from the host country, an extradition treaty, or a foreign court. It functions entirely through domestic agencies acting on their own records. And it costs the Treasury nothing, which the Budget Committee confirmed in writing. That combination is what makes a policy exportable. Any government that wants leverage over its citizenry beyond its reach now has a working template. The counter to it is unglamorous and well known to anyone who has been doing this seriously for a while. A second nationality issued by an unrelated government, with banking, residency rights, and the documents to match. 1 passport is dependency, 2 is optionality. Every measure on that list depends on the same precondition, which is the state being able to see the money and reach it, which raises the obvious question of where financial information travels and where it doesn't. We made a video on 8 countries that won't report your financial data. It's on your screen now. Give this one a like and subscribe with notifications on if you want our coverage of program changes and policy shifts as they happen.